Welcome, everybody. I hope everybody, as we are letting people in, had good holidays and aren't too cold like we are here in Minnesota. If you want, you can share where you're viewing us from, what state, city if you want to, but what state, and we'll get started in just a minute or so. I'll also add, I'm going to follow up with people who registered with questions next week. So if you had questions in your registration, I'll follow up with those next week. Um, all right, we have some northern people here. All right. To see some familiar names in the people who are on here. Yes, Minnesota, we had squalls, which is like it was like a short-term temporary blizzard. And it looks like the names have stopped rolling in. So I will get started here. So I'm Josh Kroll. I am the Adoption Subsidy Resource Center Program Manager. I've had that role for 15, 16 years. Prior to that, I supported the program and I have been with Families Rising, formerly known as NACAC, for almost 27 years now. So I've been here for a little while. Today, we're doing this webinar on adoption assistance eligibility and benefits. And this is a generic one. It's not going to be specific to your state. It will give some good information. I still think important information. And this also is a good way to connect with us in case you have specific questions for yourself, your family, or families that you're assisting. Because I know there's some people on here that are helpers, that are, workers or navigators themselves. Um, and we did have 35 different states registered. So I really can't be too specific about your state, but if you have questions, you can always follow up with me afterwards. Just know for people who are watching this live that I am out Friday, Monday, and Tuesday. So I'll be back in the office on the 11th after this session. But I will get back to you. So um, that was a little bit about me. Hopefully you're excited to learn about adoption assistance. I'll also call it adoption subsidy. I think we had someone, yeah, we had at least one person from Washington State. That's adoption support. If there was anybody from California, it's AAP we're talking about. Everybody uses different terminology. So it's one of the things that sometimes helps me figure out where you're from, if I don't know that already, is the terminology you're using. A little bit about our organization. Our mission is to amplify those with lived experience, assist adoptive, foster, and kinship parents, educate children or child welfare professionals, and champion the well-being of children and families. Um, we support adoptive, foster, and kinship parents and young people, educate child welfare professionals, and advocate that children and families have support. So today, these are the things I'll be going through. This is being recorded. Um, and we will have a couple of breaks where if you have any questions, you can put them in the chat or question and answers. Becky has done this many times. She's our super guru on so many aspects at Families Rising. She might be able to answer the questions or we might discuss them during that. But if it's more personal, just reach out to me directly because I mean, she'll ask it generic without saying who it's about. If it's if it's private to us as the presenters. But you always can get a hold of me. But today we're going to cover special needs definition, Title IV eligibility. And there's some people who registered definitely have already adopted children, so I'm going to cover that a little bit. What benefits come with adoption subsidy, negotiation, because that matters in some states, not in all states, renegotiation, because Sometimes children's needs change and families need more support. Interstate adoption, how that works, whether you've adopted from another state or moved to another state. When does the adoption assistance end? Social Security and subsidy, other welfare programs, how do they interact with adoption assistance, and then college assistance. And at the very end, I'll do real quick, one slide each on claiming children as dependents and the adoption tax credit. So the special needs definition. Um, to qualify for subsidy, the child must meet the special needs definition. And it's really hard because when people hear the term special needs, they think an individual with a disability, right? Think about Special Olympics. We just had the Olympics this past summer. And then there's really great promotion of the Special Olympics, and that's individuals with disabilities. But it also, in child welfare, the law says special needs, but it also means kids who are hard to place, who may not actually have a disability. The other thing that sometimes happens, especially for newer families who are in the child welfare system, they may think of disabilities more of a physical disability, which are more obvious and seen, but a lot of children, whether through trauma, or maybe exposure to drugs prenatally, or just inheriting possible mental illnesses, there's a lot of the hidden disabilities, behavioral issues, mental health issues that may exist. And that's probably as prevalent, if not more so, than the physical disabilities for children in the public foster care system. Now, we're going to go into some of the ways states define special needs, but there are 3 parts to the federal definition of special needs. One of them is allowed to be set at the state level, and that's what creates such variation from state to state. That plus rates and a lot of different things. So the federal definition consists of these 3 parts. The first is the child cannot and should not return home. That's a judicial determination that is typically made in the month of removal, when that child's first removed from the birth family or first family and comes into the foster care system. So if you've been fostering that child, or even if you're a kinship family and you're the first placement, that is something that the agency, the child welfare system, is doing that you wouldn't typically be a part of. But that's something that generally goes pretty smoothly. But I have heard of a few cases. I mean, if you think about 27 years, I've heard of 2 cases where that didn't happen and the child was still eligible for adoption assistance. However, they didn't qualify for federal funding when that was not done correctly. But generally, that's not a big issue because the states want to ensure that they're getting reimbursed federal dollars, and they don't want to miss out on that because it's at least 50%, and it can be as high as in the 70%. And states, they generally have to have a balanced budget, so they're doing everything to maximize their revenue. The second one, and this is one that can be scary, especially if you're a new family, but also may not happen, new to the whole child welfare foster to adopt situation, is that there are reasonable efforts to place the child without adoption subsidy. The feds have made it very clear in policy that the state is not supposed to they're not supposed to shop around. They're not supposed to say, hey, this is a child the foster family's not willing to adopt. We haven't found any family members who are willing to adopt, so we're listing them on an exchange. It could be adopt you as kids. We're listing them on an exchange, and we have 3 families interested in this child, and we think this family will be the best match. So we go up to them and say, hey, we want you to adopt. Here's full disclosure. Will you adopt this child without adoption assistance? And the family says, no, we need adoption assistance. They're not supposed to then go to family number 2. As soon as that family says, no, we need adoption assistance, adoption subsidy, adoption support, they're supposed to then talk to you about it and then negotiate it. But what's scary is if a family is relatively new, they don't hear this, they might say, oh my God, if I say no, maybe they'll try and move the child if I've already been fostering the child. That's not the purpose of this. And there are exceptions, and this is why some people who are either kin or have already been fostering the child may never have this question posed to them, is if you already have an established relationship with the child, they may not even ask that question. But if it comes up, that's a federal law requirement, and it shouldn't just scare you away. If you're getting close to that point in the process and you want to talk about it, give me a call. The last part is the state definition of special needs, and we address it. Actually, we don't have numbered questions anymore. I'll update that for the slide on the web page. Sorry, I was updating things today. I just overlooked that. But if you go to our website and then go to the adoption assistance, click on your state, it will be towards the beginning after all the links for each state. So we're going to talk about what types of qualifications a state might have. I think every state, quite sure every state has a child who has a documented physical, mental, or emotional, or developmental disability qualifies as special needs, is hard to place. So the key here is it has to be documented. Remember, the folks who are processing this information, they're government. Government, like many things, but particularly government, is a bureaucracy. They need to be able to document things. And so they need a written, they need something from a qualified professional that the child has been diagnosed with this, or this to qualify. I've been doing this long enough. I've met foster families who've been doing this 20, 30 years. They're super experienced. They see the issues, but they don't have the proper initials typically behind their names to be able to document it for the bureaucrats. So it needs to be documented. So like if you're an experienced parent, you're seeing the issues, you need the professionals to document that. And Becky just put the link to the webpage in the chat. So you can select on the map your state. Age, most states have age as an eligibility criteria. It can be as low as, well, it's now in Indiana, it's all ages. Illinois, it's age 1. Indiana used to be age 2 until July 1st of this year. The state of Minnesota, Georgia, and Massachusetts do not have age as a criteria. Most common, it's going to be 3 or 6, might be a little higher, depends on the state. But most states have age as a criteria, but Minnesota, Georgia, and Massachusetts do not. Race or ethnic background or minority, that's going to depend on the state. Many of the states in my years of doing this work have changed those to make them a little more restrictive. There have been some states where it was maybe a certain race, but now it's that race plus an age, like over the age of 2, instead of just all kids of that race. And it could be just certain races. The most common would be African American or Black. I know some places in the South in the past, I remember talking about this in Alabama once, and in Alabama at the time, it was, not Hispanic children, just African American Black children. Some states may say that it's certain races that have slower rates. And I have a typo here too. Geez, I need to do a little updating before I send this to Becky, that have barriers to adoption due to overrepresentation in care or slower rates of permanency. And that's typically going to be African American, Hispanic, Native, less likely to be Asian. And I think states that might have that might be New York and Connecticut. But states may have that, but not all states do. Some states don't address that at all. So that's kids who are hard to place. We also have siblings. It could be anywhere from 2 to 4 siblings, depending on the state. There are a lot of places where it's just 2 siblings. Sometimes it could be 2 siblings if one has another special needs or is over the age, or 3 if there's no other issues going on or no other qualifications. I think the 4 siblings might just be South Carolina. The best sibling definition out there is to join a sibling already adopted by the family. I know Texas and Minnesota have that. Sometimes birth parents have children after an adoption happens. They might have another child and they may be removed at the hospital, which is unfortunate. Sometimes the states will then look to keep the siblings together and approach the family. And what's really great is the states that have to join a sibling already adopted by the family is they might be at a financial situation where they can't adopt another child without support. And a lot of times these are really young kids, they're, often infants that may not be showing anything. They may not qualify any other way other than being adopted by someone who's already adopted their sibling. So any state that has to join a sibling already adopted by a family, those are always like the best for the sibling criteria. Quite a few states, but not all states, have deferred agreements, and these are usually $0 agreements. They usually come with Medicaid, or you may be able to ask for it, but you should always ask for the Medicaid. And then they also usually can come with the non-recurring adoption expenses. Now, for the folks from Georgia, because there's a large number of people registered from Georgia, my understanding, unless it's changed, is Georgia's one of the only states I know that does not provide any of the three benefits. They still do a $0 agreement. It's still better than nothing because it's a safety net. But it's a pretty bare bone safety net to start with. And it also will impact the ability to take the adoption tax credit later on. Typically, with the high risk, the state has to be able to document the risk factors to qualify for this. But there are a lot of states, it's not too hard to do that. It's, it could be past trauma, neglect. There are states where almost every kid qualifies for adoption assistance. And your state might be one of those, but not all of them are. If you were in a situation where they said your child is not eligible, feel free to give me a call and we will go over what your state specifically does and talk about factors. Because there are definitely times things like that happens. Like 2 years ago in Minnesota, a family was told they will only get the high risk. And I'm like, well, what's going on with the child? And they actually had some serious medical issues, not super serious, not like, total care or anything like that. But I'm like, the family shared the email of the denial from the county, and the county was very like, do you have more information to share? And I'm like, it doesn't look like they know about that medical condition you've been sharing with me. You need to go back. And as soon as they did that, it was approved for the monthly payment. So if you're ever in a situation where you're being denied the child's eligible for adoption assistance, I'm more than happy to talk with you because let's try and figure that out. It's always better to figure it out from the get-go. So, so someone asked in the chat, can I clarify what a $0 agreement is? So it's typically, it has different needs. Iowa calls it future needs, but it's a deferred or $0 agreement. And it's an agreement of $0. And this is, I didn't explain this well. This is the safety net portion of it. It has an agreement so that if problems arise later, you can go back to the state and say, my child now has this diagnosis. We want to talk about getting the monthly payment started now. It's typically going to be for younger children who might have a disability that isn't apparent yet. Because really young children, they might be, there might be some delays going on, but they don't want to do a diagnosis. A lot of times those don't happen until school age. So you have that $0 agreement and it makes it easier to go back because if you don't have a $0 agreement, I mean, also the Medicaid can be crucial, but if you don't have that $0 agreement, and then you go and say, I need to get adoption assistance post finalization, the state will deny that, and you can appeal that, and then they'll look at the factors of the case, and it might get approved, it might not, but it's a lot harder and it takes longer to do, and it costs the state more money. It creates more stress for you as the family. So it's the $0 agreements are a safety net that allow families to access the monthly payment and other benefits later on. So, if you're in a situation where your child isn't meeting any of the other criteria, but you're offered that, always say yes. So I just, it's a good safety net for the state and for the family. Um, so hopefully that helped. If not, follow up with me later. Not all states do it. I know Texas doesn't, and families have to go through the appeal process, but I know families have been successful with that. And families have been successful in other states, but I know I've talked to a couple who have been successful in Texas where they do not have a $0 agreement. So it all depends on the state. Um, so Title IV eligibility, this is for the most part not a big issue for new adoptions, but I still want to go through some of this because it's important for adoptions that have already happened in the past, and it can it can matter if something were to happen with the adoption. So Title 4E is the part of the Social Security Act that reimburses the state for what they pay in adoption subsidy dollars. Um, and it's anywhere from 50%, it's never lower than 50%, and it can be a little higher than that if there's, like COVID or, the big recession we had back in '08. There can be things that the federal government does to bump every state up by a certain amount. But generally, it's 50% to somewhere in the 70s. Um, and that is money that the state gets reimbursed based on what they pay out for children who qualify for the federal funding, which we're going to do on the next slide. When it isn't, then it's all state dollars or state and county dollars. For the 4E, the non federal share, the remainder of the percentage is going to be all state and or county dollars, depending on the state. Sometimes I actually had an email about this just this week. And sometimes I get calls like this. Sometimes people are like, so I get this subsidy from Minnesota. I heard about this federal subsidy. How do I apply for that? Like what's the federal agency I do that with? And you don't. It's always administered by the states, and it's either a state non-4E or federal 4E adoption subsidy. You're always talking to the state. There isn't, unfortunately, a second pot of money that you get to apply for what's called adoption subsidy or adoption assistance. So how are kids 4E eligible? In the past, there were only 4 ways for kids to be eligible, and I'm going to go through these really quick, except for number 2 and 3. I'll spend a little bit of time on. Um, you had a foster child who was a minor, who was a parent themselves. They had an infant, and the Title 4E foster care payments covered both the minor parent, who's your foster child, and their infant at the time the adoption petition's filed. That'll make the infant Title 4 eligible. I'm going to skip down to number 4. The birth parents were AFDC eligible. This is still how most kids in foster care are eligible. It's really messed up because they're using AFDC was welfare before welfare reform, and they're still using income guidelines from 1996. And we all know, I mean, things were higher before the recent years of inflation, but even more so in the last couple of years. But the income guidelines are stuck in stone from July of 1996. It's just insane. Almost 30 years now, over 28 years. What also is insane for the adoption subsidy part, not the foster care side, is they never did a redetermination of AFDC eligible when the birth parents had their parental rights terminated. So that's those two. That's going to also, help kids in the foster care. The child is eligible for SSI, Supplemental Security Income, SSI, and that can actually make children outside of the foster care system eligible. It's not a guarantee, but it is a possibility for kids who qualify for SSI. But that's typically going to be children with significant, often physical disabilities, not always, but often physical disabilities, like, a private domestic adoption if the child's like got Down syndrome or cerebral palsy, spina bifida, things like that. The next one, I want to spend a little time on this, is the child received Title 4E adoption assistance in a previous adoptive placement. So if I adopt a child, I get Title 4E adoption assistance, and something happens to me. Let's say I die, and Becky has become friends with me and knows the child well. She says, I'm going to adopt that child. Child does not need to re-enter the foster care system. she can do the adoption. And if she does the adoption, she just needs to apply for that adoption assistance and hold off on finalization until she gets it approved. Now, when the child's not in the state foster care system, she needs to apply in this situation, this scenario. It would also work for dissolution um, of adoptions, like second adoptions, but also death and dissolution. Um, if she's in another state, she lives, not far from me, but let's say she lived in Wisconsin, she would then apply in Wisconsin, even if Minnesota paid it originally. If the child does not re-enter foster care come into the state's care for that subsequent adoption. So this covers both death and dissolution, as was mentioned in the chat. And I'm going to read what Stephanie wrote later on when I get to the Social Security section. Because I know I have a lot of other things to there, but I'll read it when I get to that section. And hopefully it'll still not be too hidden there. And you can't all see these chats because they're just to the host and panelists. So sorry about that, but I've got some comments going on. Now, Congress and advocates and states particularly realize there's this huge issue with less and less kids being Title IV eligible because we're looking at 1996 guidelines. And it wasn't actually that long later. It was only in 2008 that it passed, only 12 years later. And so at that time, they said children in foster care for 60 consecutive months or 16 years of age or older will qualify as Title IV eligible as an applicable child. That started October 1st, 2009, and the age kept dropping. And then it was all ages. And then Congress clawed it back and said, no, we're going to wait like 4 or 5 years and say it's just kids 2 or older until that ended July 1st of this year. So at this point, all kids should be Title IV eligible. But on the next slide, I'm going to say, and this is for existing agreements, because there might be people out there who have non-4E agreements that have already existed. That's why I'm going through this, because I'm trying to be comprehensive. I don't know everybody's situation. Why does Title IV matter to you? Why does it matter in the world? First of all, it saves the state money, right? I mean, when states are hurting for money, they look at things to cut. The less adoption assistance costs the state, the better things are for them not looking to reduce the rates. Because that was proposed a couple, I think Oregon in 2002 and some other states over the years. It matters. For the state of Ohio and Louisiana, they actually means test. They look at the family income and say, oh, you make too much money, you don't qualify for adoption subsidy for the child. They can't do that if it's Title IV, but they can if it's not, because it's their dollars. They get to make the rules. Those rules come with some conditions. Some states will not provide Medicaid to non-4E children unless they have a disability that warrants the Medicaid. So for, I could adopt a child, I could get a monthly payment, but not Medicaid unless they, the child's hard to place. Maybe they're over a certain age, maybe they're a certain race, but they don't have a disability. They get that monthly payment, but they don't get the Medicaid. And then some states can operate their non-4E program a little differently. I don't have a good example there, but I mean, it will happen. And then there's also can be issues moving states, and we'll address that later on. There are some states that still do not provide Medicaid if the child receives non-4E adoption assistance from another state. The last one I'll actually add in here is the Title IV. Also, the other really big thing that's really helped is in Minnesota, I think it was 2011, and Pennsylvania in 2009, there were budget fights. There was, differences between the legislature and the governor, and they didn't pass budgets. And then there wasn't money authorized for that next year. And then, there's all these lawsuits and things like what are essential programs and all that. I actually have I tattled to the feds when the state says we have to do what we have to do, because there's this whole bureaucratic chain, and they're like, well, we're this is what we have to do. We're not going to fund this program because we don't have a budget to work with. But the feds have made it very clear that the state can't not pay adoption subsidy for Title 4E programs, because there's a budget issue. This is an obligation. They've signed a contract. These adoption assistance agreements are a contract, and they have to meet it. They can't, even if they put in the wiggle out language in your agreement, which often happens, that, they'll pay this depending on the budget. That's something we can successfully fight by just having the feds say, no, you can't do that. And hopefully, my experience has been they haven't been wise enough to, um, maybe Maine did at one point, but in general, I don't think they're wise enough to say, oh, then we'll just only fund the Title 4A kids, not the non-4A kids. You don't share that with the state people, and they might know that well enough and don't want to split that, and they might just play dumb. I mean, the state people don't like those situations. I'll promise you that. But they have to do what their supervisors say until the feds tell them contrary. So that's another reason why Title 4E matters. Um, Benefits. Um, are there any other questions other than Stephanie's that I'll address later, Becky, at this point? If not, I'll run through negotiation, renegotiation.
Not yet. Go ahead with
Okay,
negotiating.
I'll run through the benefits and the negotiation parts. Okay. So how does adoption subsidy help families? Well, there's that monthly payment. It's, people use different terms, basic maintenance, per diem, stipend. Generally, the basic amount is going to be for children who are hard to place or have minor disabilities. Then you can have difficulty of care, level of care, SSI rate, special care increment, therapeutic, medically fragile, specialized. States use all different rate names for their different rates. And exceptional, intensive, or they use CAN scores. And these are going to be those higher than the basic rate, and they're going to be based on generally the child has a disability to get the higher rate. In Minnesota, we have something called the MAPC. It's got 15 different levels. Interestingly, in Minnesota, they've incorporated, and this is in foster care too, they've incorporated the child care portion into that assessment tool. So you could actually get a higher than the basic rate in Minnesota for a child that doesn't have a disability, because there's a child care need or aftercare need for that child. But that's not very common. There can be other services out there, but that's going to depend on the state. Some will do child care for children, but it's run through a different program. And unfortunately, some of those require you to reside in the state. I remember talking with a family in Vermont who had then moved to New York, and their child care support ended when they moved from the state. And there wasn't a way to replicate that or provide that to them outside of Vermont. So you really, some of these things you really have to look into. How does the state operate things? So there's also the Medicaid we talked about earlier. It's automatic with 4E, non-4E kids. At this point, most kids should, or almost all kids should be Title 4E, so it shouldn't be an issue. But so if you've already adopted and you weren't able to get Medicaid because child didn't have a disability, you know why. That's why. There's a reimbursement of non-recurring adoption expenses. It's up to $2,000, but the state may set a lower limit than the child. This reimbursement can help you with attorney fees, traveling. Let's say for the Minnesota folks, you live in Minneapolis, but you're being matched with a kid in Moorhead, which is just outside of Fargo, 3-hour drive. You're doing some pre-placement visits. You're driving up there, you're staying the weekend, you're getting hotel rooms, you're paying for food while you're there. Those are things that can be part of that reimbursement. In some states, I want to say Indiana, Florida, Texas, you have to get an attorney. They all magically cost that exact amount. So it doesn't really help you. This also doesn't help you. Let's say you were planning for up to 2 children. You get matched with a wonderful sibling set of 3. You need to buy a new bedroom set and clothes and stuff like that for that 3rd child. It's not going to help you with that. It's related to the legal process of adoption. Could be background checks, court costs, or, new birth certificate, things like that. Reimbursement up to $2,000 per child. And the other thing I'll say here, if you've already been fostering a child, or children, when we talk about these different rates, you might have, especially if you've had more than one child, that the children have different rates and can be based on age and or level of need. This is just the same thing in adoption subsidy. Um, so we're going to talk about negotiation. Now, this is not an issue everywhere. So your state, I'm trying to think, let me look at the list of states here who signed up for this. I know I got Washington, Alaska on this list, Montana. I don't know. I haven't talked to many people from Montana recently, but I know a couple of people commented. Oklahoma, Georgia. Um, so not Minnesota, we don't really negotiate. So negotiation can be a challenge depending on the state. Maryland is a negotiation state, and there can depend on the county. So we're going to talk about this in a couple respects. So the first issue is federal law says the state can't get reimbursed. Florida too, they negotiate. It's going to depend on the agency there. They can't go higher than the foster care rate. I mean, technically they could, but they wouldn't get federal reimbursement higher than the foster care rate. So that's really what states look at to say we're not going above this because we're not going to get that federal reimbursement for anything above this. I mean, it's one of those situations where I think they're like, well, that makes sense. The child's needs, this is what we say is the maximum, so we're not going to do more than that. We would do it for foster care as much as for adoption. So I think the states use that a little bit in saying why they can't go higher, but it's all based on a really logical reason. Federal law limits it. States can have lower maximum rates and offer that amount without negotiation. For example, in Minnesota, we have this structural problem we're trying to fix. We've been unsuccessful for a decade, but we're going to keep trying, where kids who get permanency before the age of 6, this is adoption or guardianship, who get permanency before the age of 6 get half of the foster care rates. That's not right, but that's our law. It's in our law. They don't have to negotiate. They'll just like, oh, you're getting this much for the child? Well, you'll get half of that now. If the child was 6 or older, you'll get 100% of it. We don't negotiate. But that's a structural issue for the person who commented from Washington State. They put into I think it's in code that they can't get more, depending on the age, anywhere from 80 to 95% is the ceiling in negotiating the adoption support rate. In Texas, the rate is 400 or 545 unless it's one of the roughly 20 kids a year that qualify for the enhanced program. In North Carolina, there's a program that lets them go over the basic rate for kids who aren't HIV positive, but it's only if the county participates and there's money in the program. Like there's all these crazy things out there, but in Washington State, they will have to negotiate. The ceiling is lower though. So I always recommend to people that they ask for the maximum amount that the child qualifies for. Just know that rate might be lower than the foster care rate, or that foster care rate, like in North Carolina, may not even be possible. So it's really going to depend. So anybody who's dealing with this, or you're in another state where they're really negotiating, like Indiana really used to be a challenge to negotiate. Now they're just offering everybody 100% of the foster care rate. Ohio, depending on the county, can be challenged to negotiate in. Colorado used to be a challenge. Kansas at times. And anybody from Kansas on here, just know that you can ask for an exception to go up to the foster care rate. That's not always well advertised. So anybody who thinks that you're going to have to negotiate in your state, feel free to reach out to me because I'm happy to talk to you. But here's some tools coming up that I'm going to cover for you. Here's some philosophy and then some federal language. The state is saving money. If you think about it, when a child moves to permanency, they're closing that foster care case. That costs money to have that person, whoever's the worker, that costs money, as well as the courts, that costs money. Once you finalize the adoption, you're saving money. And guess what? If that kid was in Title 4E in foster care, but they now are in adoption subsidy, they're saving money. Why not do that? The child's needs haven't changed. Matt, I don't know anybody out there who's ever told me that the child all of a sudden had less needs because they got adopted that day. I mean, we know that there are children who really want to be adopted, and that gives them comfort. I mean, I've talked to many of those families over the years that, we're talking about options, we're talking about resources, support, and they think, they might do something that ends up meaning less support, but for uh, the mental well-being of their child, they think adopting now and not waiting is worth it. That's their call. They're the parent. They know the child. I can't make that decision. All I can do is give information so that they can make the most informed decision with what I know to help them. But generally, children aren't magically, that's not any, there's no issues anymore. Um, the other thing is document everything, get diagnosis, get it in writing, throw the kitchen sink at them. Um, if they ask for expenses, give them everything you can think of. I know sometimes states will say that the amount of the adoption subsidy should be based on the out-of-pocket expenses for the special needs of the child. I've seen that multiple places. And I say, then why are kids over the age of blah, 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 or sibling groups of blah, blah, blah in your state eligible for this? What does that mean? They only get $0 with, a Medicaid card? That doesn't make any sense. It's like, it just makes zero sense at all. But if you're in a situation and you think it's going to be a challenge, feel free to reach out to me because I might have a good sense of what your state's like. And I've, 27 years of experience, doesn't hurt. And there will be no judgment. We're all talking about maximizing resources so that your child has the best chance of success. That's what the whole purpose here is. So I'm going to not go through this a lot because, I mean, reading law is super boring, but this is federal law, 42 U.S. Code 673A3 or Social Security Act 473A3. And the key part here is the needs of the child being adopted. So it says, in determining the amount, blah, 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 which shall take into consideration the circumstance of the adopting parents and the needs of the child being adopted, and may be readjusted periodically with the concurrence of the adopting parents. End of story. So that is just talking about the needs of the child. That means room and board, in my opinion, when we talk about expenses, not the out-of-pocket expenses for the special needs of the child. Okay. So child welfare policy manual, this has, this goes through a lot, but I'll just go to the second side. Well, I'm going to highlight one thing here. The adoptive parent's income is not relative to the child's eligibility for this program. Remember when I talked about Title 4E and I said Ohio and Louisiana means tested the program? That they can't do for Title 4E kids. So at this point, they shouldn't be able to do for anybody. But for the non-4E kids, they said you make too much money, you don't qualify. The child doesn't qualify. It's just insane. This is saying that. And it seems counterintuitive, but they do talk about the negotiation that the payment that is agreed upon should combine with the parent's resources to cover the ordinary and special needs of the child projected over an extended period of time. It should cover anticipated needs, example, childcare. Now, I'm going to break this down real quick for everybody. Sometimes people will say they can't look at my income, and it's like, well, no, they can. This part, looking at the parents' resources, what can the parents bring to the table, and what can what does the state bring? It's really annoying at times because it's like, wait, if I'm saving up money for retirement, or maybe you have another child and you're planning, that has a disability. Some families I've talked to have like a birth child with a specific disability. They're like, we know this disability really well. We're interested in caring for a child, where we're already experts at what their needs are. So that sometimes happens, but like they need to plan for what's going to happen when they're not around to help care for that child, because some of these children need help their whole life. And the parents aren't, unfortunately, always going to be there sometimes. Depends on the situation. So it seems really messed up that, in some situations, that if the family has any disposable income, it will hurt them in the negotiation process. I've definitely heard that from some families. It's like really messed up. It's like, so someone who's like totally paycheck to paycheck will get more support than a family that's able to squirrel away some money for whatever. Doesn't seem fair. It really should be based on the child's needs, not necessarily the resources of the family. But this federal policy does allow that to happen. That's why we are really happy when there's states that just don't negotiate. They're just like, this is the maximum available, this is what you're going to get. It's also much easier for the families. They don't run into situations where like, well, don't you love the child? Aren't you really why are you worried about the money if you love this child? And it's like, well, this child has a lot of needs and I need support for them. And I don't know if this is gonna be enough support for them. So renegotiation. So I do see that comment there. I'm gonna cover that. I'll address Brandy's comment at the end of this renegotiation part. Um, so you can request a change at any time, and usually families are seeking an increase in the amount of support, the monthly payment. If you have one of those $0 agreements, you might be getting that monthly payment activated. You need to document the changes. What are the new diagnoses? Did the diagnosis come from a proper professional? Depending on the state, and how the process works overall, you may also want to talk about, you may need to, document what the expenses for, what sort of services you're looking at paying for. You can run into issues like, oh, the schools are supposed to cover that, or Medicaid's supposed to cover that. That can happen, and that can be something that causes them to come in at a different amount or lower it, or maybe not even approve a change. Um, you could also request a change, especially if you're not at the maximum amount the child would qualify for. Like this would be Maryland or Washington, of the folks I know on here for sure, are states where this happens, can happen a fair bit. Um, is that you can, if you're not already maxed out based on the child's needs and they haven't really changed much, but you had a lower amount and your family circumstances have changed. It could be like Brandy's saying here, that, maybe they had a lower amount than the maximum, but prices are getting higher. That can be a reason. Or maybe you just aren't able to work full time. You move to part time because of all the appointments or other things that you're needing to do that are covered, but it's just taking your time. That can be a ground to renegotiate up to it. So I'll give an example. Let's say Maryland, the maximum, it's around this, I don't know the exact number, but let's say it's $1,000 for a basic child, but I negotiate 700. I can renegotiate to 1,000 if the child's needs haven't changed, up to that, that 300 difference, even without a change. But I got to make the case. And some counties will be easier, some it won't. Um, so that's just one example out there. But always request the change in writing, create a paper trail. If something is um, if something is denied, you can appeal it. If you win the appeal, it should go back to the date of the first request. If you call me and I say, oh no, I don't, I mean, I might be really honest with you. There's a lot of great workers who are just really honest, like, I don't think that'll get approved. They discourage you from formally applying for it. They might be saving you time and effort, but they also could be wrong. Um, People have a sense of the people they're working with. But if you request it in writing, you will get a formal denial. You can appeal it. If you do win that appeal, it should go back to the date of request. But if you get a verbal denial and then you come back to it a year or two later and you do it in writing, and writing can be a text, it can be an email. But if you're just doing it verbally, you really don't have that documentation. Um, so I always request that. And then, some families have adversarial situations, creating the paper trail also just helps them document how the whole conversation has gone, and prove that they made that request. Some states require that the disability be tied to an unknown problem that was present before adoption. So like, let's say I adopt a child, I get adoption subsidy, I get into a car accident because I live in Minnesota and it gets icy and snowy here. I get in a car accident, the child's now in a wheelchair. Well, that's because I got in a car accident, just like any first family, birth family would have done. And they won't, some states won't increase it based on that. They might increase it based on, the child we've discovered qualifies as FASD. We've got that diagnosis now. And obviously that's a prenatal exposure thing. Or there was something, there was, mental illness that is hereditary, but it didn't manifest until the child was older. Not a problem. I already covered change in family circumstances, ground for asking for a change in adoption subsidy. Um, um, so, um, and I see some more text, so I'm going to get to those in our chats in a second. Some states do not allow for renegotiation. Texas, no. Maryland, you can renegotiate up to the foster care rate at the time of adoption. That'd be a great thing to change because most states allow it to go up to the foster care rate the child would currently qualify for, but they lock you in. In Michigan, you got to get that settled before you finalize. If you finalize, you're locked in. You cannot get higher than that rate. You can access the medical subsidy program, but you're locked in at that rate. In North Carolina, they don't technically say you can't renegotiate, but they have one rate based on age for everybody. They have um, rates for HIV kids, and then they have this special incentive fund that some counties participate where you can get that, but that has to be done prior to finalization. It's not available for later on. So essentially, those kids are locked into the rate. The one thing I'll say for North Carolina, and it helps me lead me into something else, is if your state has different rates based on age, and I need to track this down and have the list sometime. I don't have it yet. Some states, North Carolina is for sure one of them, Minnesota's another one, automatically increases the rate for the family. They don't have to request it when the child goes from like age 6 to age 7 or whatever the age brackets are. They automatically increase the amount. But other states that have that difference in foster care, a lot of them you might have to request that. So if your state doesn't give you an automatic increase, but um, you but the rate can increase in foster care, you want to reach out to them and ask for that increase. It may or may not happen, but you may want to do that. Kat, to your question, what state are we talking about? And for Brandy's question, the price of everything rising and we are getting what we were getting when we first adopted in 2014. Can we negotiate the subsidy we get for her, renegotiate the subsidy in Montana? You definitely can look at renegotiation. The big issue is, has your state changed the rates over time, or has the needs changed? That's going to be the big issue. So I would do that. And then Calvin and Fawn raised their hand, but I don't have a way with my setup to take people off. If you have a question, you can put it in chat or in questions. For New York State, for Cat, Kansas, you definitely, if you only got $60 a month, I would definitely, you can definitely renegotiate at least to 500 a month for Cat. And if your state has increased rates, you can definitely ask people about renegotiating. New Jersey, I don't know if anybody's on here from New Jersey. New Jersey is really complicated. Depends on the year you adopt and what you can renegotiate to. There's like, whenever they do increases, there's all sorts of limits on previous adoptions, what they could do. Not every state does that, but some states, when they do increases, only allow it for new adoptions, not past. Like anybody, because we had a large Minnesota contingent, if you adopted before 2015 in the legacy adoption assistance program and not the North Star Care for Children, you do not have access to the North Star Care for Children rates. You only have the legacy rates and services available to you. So it depends on your state, but people can reach out to me directly on it. I'm going to keep going. Any questions, Becky, at this point? Because now I'm going to get to the more interesting, weird stuff.
It was more what you've already answered, that people are asking if it's 10 years later, 13 years later, how do
Okay.
they know
Yeah.
if the rate has changed?
Yep, and folks can reach out to me directly. Like I said, for those who are on here live, I will not be responding until next Wednesday, but I'll work through the emails I get. Probably the easiest thing than voicemail, although I'm always happy to talk to people, but um, it'll probably be fresh in your memory and easiest to shoot me an email at this point rather than leave a voicemail. Um, so I'm gonna go through the weird stuff now and then the tax stuff. Trying to oh dang. All right, I've talked way too much. So I'm gonna try and make this we said an hour, it's usually 75 minutes, but I'm pushing that. So I'm gonna rush through these and I'll address questions at the end of this. So I'll hold off on Stephanie's question till the end of this too. Interstate adoption, when children are in the state's foster care system, the adoption subsidy comes from the placing state. So if I'm in Minnesota, I'm adopting a Wisconsin foster kid, a kid in the Wisconsin foster care system, I need to look at what is Wisconsin's definition of eligibility, definition of special needs, what is their rate structure. The Medicaid, though, will need to come from the state of residence. So that gets transferred. When children are receiving non-4E subsidy, it can be a problem, but it's less and less so now. One, because more and more kids are 4E, but also because less states are a problem. So all kids who receive Title IV adoption subsidy are statutorily eligible for Medicaid. So the person who lives in New York but is adopted from Kansas, they got it transferred because New York does that. They didn't always, but they do that now. So here's the states. I'm going to just run through this a little faster since, we're almost already at 4. Illinois, New Mexico, and Nevada will not provide Medicaid to children adopted from any other state who only receives a non-4E subsidy. Okay, so if I have a non-4E subsidy, even if I have Medicaid in my state, which most states do, but I move to one of those 3 states, it will not transfer. They will not provide Medicaid. I don't know if there's a great solution. You can always reach out to me and we can talk about it. Iowa and New York will provide it to any other state except for kids who receive non-4E subsidy from Illinois, New Mexico, or Nevada. They used to not do it. They do now. Hawaii, in my time, the states that have come off this list are Iowa, New York, New Hampshire, DC, and Hawaii. Hawaii just in the last year. So if anybody is in Hawaii, lovely place, and didn't get the adoption subsidy transferred or didn't get the Medicaid transfer because they had non-4E subsidy, they need to reach out to them. The most important thing I'm going to tell you here, this is actually not super important. You can always reach out to me and these numbers change. We get this information from the Association of Administrators and the Interstate Compact on Adoption Medical Assistance, because they're the ones that actually help the states do the processing. Most important thing for you, if you're a parent, to know if you are moving to another state, do not apply for Medicaid yourself in that new state. That will give you endless headaches that you do not need. What you need to do is let the adoption unit know that you're moving to another state so they can send the paperwork over. One, they should know where you are because you have a contract with them. That is probably part of your contract, is you to notify them when you're someplace else because they might need to follow up with you related to your contract. But more importantly, they're the ones that are going to send that paperwork over to you. Okay. So, or over to the state and get it set up. It's going to save you so much grief to do it the right way. That's the right way. When I talk to state people, especially state administrators, they are so happy that I always cover that in these presentations because it's just making life better for everybody to know that up front. Oh, And if you move to a third state, some people move a lot. I'm not one of them. I've never lived except for university more than 5 miles from where I was born. But if you move to another state, you go to the state that pays the adoption subsidy, not the current state that you live in, but the one that pays the monthly payment. You go to them, or that you have the agreement with, if it's one of those $0 agreements, you go to them and you get that Medicaid sent over. When does subsidy end? Typically, it ends at age 18. Some states will continue adoption subsidy to 21 if the child has a disability that warrants continuation of the adoption subsidy. Some states will provide assistance to children still in school, usually with state dollars. That's really great for states that do that. Some states have opted into Fostering Connections program to provide extended benefits if criteria are met for youth adopted at age 16 or 17. That's typically if the child's still in school, high school, or college, and that's up to 21. If they're working 80 hours per month, if they're in a job program to help them get gainful employment, or if they're too disabled and not able to qualify otherwise. A few states, the criteria for extension will be different based on funding stream. Tennessee and Indiana are the two that I know for certain. And it's different whether the child's Title IV under the old rules or the Title IV based on the age, or if they're non-4E. It's really a mess. Hopefully over time, that's less of a mess because it's just further back in time and there aren't kids who qualify the old ways. Subsidy can end before the age of 18 if the parents are no longer legally responsible or financially supporting a child. You're no longer legally responsible if your parental rights are terminated, the child enlists in the military, marries, or is an emancipated minor. A state may determine you are still financially responsible if you're paying for therapy, gifts, etc. Talked with a family earlier this week. The child's re-entered foster care. They have been referred to child support by the state. States have the ability to not do that. I can't force them not to refer to child support, but if they refer you to child support and your parental rights haven't been terminated, the child's not in the military, married, or emancipated minor, you can still receive that adoption assistance, and that adoption assistance can be used to pay the child support that you're being ordered for. So if you run into this situation, it's never fun. It's expensive. Usually these situations are for children who need significant therapeutic help, and it's expensive for the state to provide that. It's hard on the families, the trauma they've gone through to get to that point. Always feel free to reach out to me if you're in that situation. Social Security, and then Stephanie, I will get to you, but I'll get to you at the end. If the child receives SSI, the SSI must be reduced dollar for dollar. This is called concurrent receipt of federal benefits, or you can think of it as double dipping. I think with the change to the applicable child, it might vary depending on the funding stream, on what actually happens. It might not be a dollar for dollar reduction in the SSI. What my recommendation is, well, the first thing is SSI is based on the child's disability, and and is an income and asset tested program. The child may qualify for SSI in foster care because the state or the first birth family may not have any disability or may not have enough income to disqualify that child. So the benefits might be received. The state may use it to offset their costs for having the child in foster care. There's a big battle to stop doing that. I think Maryland's been the first and most successful at changing how that works when the child's in the foster care system. Once you adopt, that child may no longer be eligible for SSI because of your income and assets. But let's say they were. What I would do is I would let the Social Security Administration know that you're getting adoption assistance. And then I would tell them, because I get these calls from Social Security Administration every now and then, that they will then call and confirm with the state what type of funding it is. Is it non-4E? Is it 4E non-applicable? That's the old rules. Or is it 4E applicable? That's the new rules with all ages. Those are treated differently. I've been trying for a long time to really understand it, and I really don't understand it. It's not clear. If anybody's got a good connection to Social Security, I'd be happy to work with them and try and figure that out. Now, that's the child having SSI based on their disability. What can happen is you might be a relative, let's say you're a grandparent that's already retired and getting Social Security benefits. You might get dependent, or they call it family benefits now, on behalf of the child off of your record, or you might become disabled, or you may pass away. If that happens, the child can get both benefits because it's a different type of benefit. It's an earned benefit. It's not income or asset tested. And um, if your state tries to change your adoption assistance because you're getting this benefit, they shouldn't unless it's Maryland and maybe Tennessee. In Maryland, they will do it for non-4E subsidy. I'd love to work with Stephanie on trying to get that changed because that would be really great to change. Minnesota, for the Minnesota folks on here, we used to have that in our written into our contracts and in our law. They're not allowed to do that for the 4E. And thankfully, when they got rid of it, they just said, we're getting rid of it. And they didn't say, oh, we're going to keep it for the non-4E. That's actually what Maryland did. They kept it for the non-4E. But in Minnesota, when we successfully fought that 5 years ago, we were actually able to do that. That was a situation where adoptive family, one of the two parents, it was a two-parent household, one of them passed away, the child started getting survivor's benefits, and they reduced the adoption subsidy. We were able to successfully fight that off. And then Minnesota has actually asked for money to go back and pay beyond that. Okay, other welfare programs. So the IRS does not count adoption subsidy as income, but other programs may count it as income as determining eligibility. So you do not report your adoption subsidy on your income tax. I want to make that really clear. School lunches count 100% of subsidy and family income. Food stamps count 100% of subsidy and family income. Section 8 housing counts $480 per year per child of subsidy and family income. So if I got two kids, I'm getting, let's say, 1,000 a month for each child, so 24,000 a year. I'm only counting 960 of it for Section 8 housing. Low income home energy assistance program. Usually it's cooling or heating assistance, depending on where you live. The state gets to set what that is. I know New Hampshire does count it. I'm happy to try and figure it out for your state. Sometimes it's easy, sometimes it's not. But if you need that program, I'm happy to look into it. Free application for federal student aid, FAFSA. They do not count subsidy and family income. Bankruptcy, Chapter 7 and 13. They don't include benefits paid under Social Security Act. Title 4E is part of the Social Security Act. I'm going to go back up to school lunches. School lunches are usually done eligibility once a year. When that is done is usually in the summer. So if I adopt that child in November, National Adoption Month, maybe National Adoption Day, that child may get it through the rest of the year. They may not get it after the next year eligibility determination. If you have a state like Minnesota where all children are eligible for school lunches, then that's not an issue. If you're a state, what I know from Minnesota, and I have seen similar things in Facebook groups, many of you may have seen these in Facebook groups, is they're using streamlined ways to make kids eligible for school lunches, and they're looking to see if they get Medicaid. But what the state people in Minnesota told us is that does not apply when children get Medicaid through adoption subsidy. And I have seen some comments in Indiana and I want to say Georgia Facebook groups where they were told similar things by their school districts. So if your state is now saying all kids who have Medicaid qualify for school lunches, take that with it may not be true. I'm not saying it's not true, but don't get too excited because it may not be true. I know that has been an issue in a number of states in the last few years, and I don't want to I want to share the concerns in what I've heard with you. So that's that slide. College assistance. These first two bullet points are all states. Children adopted at age 13 or older from foster care can apply for FAFSA as an independent student. So when you fill out the FAFSA form, and I know it's been a hot mess with the new form and all that, but if the child was in foster care at 13 or older, they don't have to put parental income on their FAFSA form. Children adopted from foster care after their 16th birthday can be eligible for education and training vouchers. That's all states. How much that benefit is and does it work if you're looking at a school across state lines, you're going to have to talk to your state or maybe reach out to foster care to success because they're the experts on education and training vouchers. But and that's a benefits out there for those great people who are adopting teens. Some states have tuition waiver programs. The states that do it, they typically have to have the child adopted from the state foster care system. Usually the eligibility is they were in state care. The tuition waived is typically for state colleges and universities of the state the child was adopted from. So like the oldest states that have tuition waiver programs that I know of, Texas and Florida, like if I adopt a kid from Florida, I live in Texas, the Texas program, there's no reciprocity to my knowledge. So that child will have to go back to Florida to use it or vice versa. So the children will have to do that. For the Kentucky kids, if they were adopted outside of Kentucky, they have to pay the difference between in-state and out-state tuition rate. The in-state portion will be covered with their waiver program, but the out-state portion they will actually have to pay for, which was really messed up. Connecticut, I think, is the only state that will allow children to go to private or out of state. They just get reimbursed up to, it used to be UConn, it's a different school, which is a lower tuition rate, but they get reimbursed up to that. But they have the maximum flexibility in terms of where they can actually go. The eligibility may be dependent on age at the time of adoption. I'd have to research. I should have done it, knowing how many people from Maryland were on here. But I think Maryland has one, but I think it's 13 or 14. Virginia also has one that's like that. The Virginia one's for community college only. You need to look at your state, and I have a lot of information out there. There are also maybe time limits on how long the adoptee can utilize the tuition waiver. Also, I know for Texas, you got to get the letter from your adoption specialist and get it to the college. I had one youth who actually still had to pay your tuition because the school charged him. He gave him the letter, like, well, that'll be for next year, but he still owed for the first year, which really messed up. I don't know if he ever appealed it, but I'm like, really? That's really messed up. I mean, um, it's really messed up. I'll just leave it at that. So, um, there's more and more states that are making these programs available. So you need to look at what the state is that typically the child was adopted from foster care. I don't know of any state that allows it for a child adopted from another state's foster care system to use their program. So real quick, we'll do the taxes. To claim children as dependents, this is for foster, adopt, guardianship. You must meet the 5 tests to be eligible to claim this credit, to claim a child as a dependent. For kids under 17 at the end of the year, that's worth $2,000 in child tax credit. There's 5 tests: a relationship test, foster children, adopted children meet this; age test, under the age of 19 or under 24 if a student; residency test, lived with you for more than half the year; support test, they cannot provide more than half of their own support; foster care payments and adoption subsidy are support provided by the state or agency, not the child; joint test, they can't file a joint return with their spouse. That's always the laugh one. The key two here, well, the first one, relationship test, you still might have some old school people say, no, you can't claim foster children. That's not true. And sometimes people will be told by tax preparers, like, well, if you claim them, then you have to report the foster care money as income. No, you don't. There are very limited situations where you do report foster care payments as income, but generally you don't. If you're worried about that, it's like if you look like a group home, or you're paid money to keep an open bed for emergency shelter, you might, for those days where you're paid to keep an open bed. But if you're in a situation where you think it might be dicey, let me know. Also, if anybody ever gets, I don't think it's going to happen. It's been a long time since I've seen Kansas, probably a decade and 13 years or so, or 14 years since Indiana do it. If you ever get a 1099 for foster care payments or adoption subsidy payments, please reach out to me. I want to work on that for you and all the families in your state. Residency test, lived with you for more than half the year. If a child's born during the year, it's more than half the year they're alive. Really, only one person should meet this test or one family should meet this test because it's more than half the year. It can't be 2 families. So the support test, the old days, you had to be more than what you were getting in foster care or adoption subsidy or guardianship assistance. But those are now support provided by the state or the agency, not by the child. So they don't count against it. It actually makes it harder for the child to have um, to provide more than half their support, because that support is support provided not by them. So it's a lot easier. If you run into questions like that, these two slides, I'll go into a little longer detail when we do our free webinar on adoption tax credit in January. So keep an eye out for that. So that'll also be free. For the adoption tax credit, you have to adopt a child under the age of 18. It's not for guardianship, unfortunately. There isn't a guardianship credit. In 2024, the maximum amount is 6,810 per child. And I see that typo too, Becky. And the benefit starts to phase out if the family's income is over 252,150. And it's not available for incomes over 2,000 or 292,150. It's based on expenses you paid, or if you receive adoption subsidy, because that's proof the state determined the child with special needs. If you receive that adoption subsidy, you qualify for the full amount regardless of expenses paid. If you receive a $0 agreement with Medicaid or reimbursement of non-recurring adoption expenses, that is special needs for the IRS. If Georgia's agreements still provide no direct benefit at the time of adoption, I don't think that will get approved by the IRS. When I look at tax stats, because I'm a really weird guy, families who make under 30,000 are likely unable to use this credit. We are trying to make it refundable again. That will help lower income families. That will help kin who might be lower income, or people who are retired, older families, or larger families who maybe make more than that, but have a lot of child tax credit crowding out this credit. Like I said, we will have a free webinar in more detail about this in January. Um, so, because, so I have one question. Are you saying you claim the adoption credit each year, only the year you adopt? You claim it the year you adopt, and you have 6 years in which to use it. Someone else, replaced 3 children from Georgia in August. They're still getting subsidy from Georgia. Okay. I don't know if there's a question there. If you have a question, let me know. We don't pay taxes on adoption subsidy, but have to pay on Social Security death benefits. We got the Social Security because it was higher than the adoption subsidy. So you may run into a situation. So you might run into a situation where the child gets benefits from a birth first family prior to being adopted. That benefit may continue with adoption, like survivor's benefits. That might be higher or lower than the adoption subsidy amount. But a lot of times the states would really like the family to take that benefit. They may not even offer anything more than a $0 agreement with Medicaid. I would, in a situation where they gave you the Social Security, I would just still do a $0 agreement with Medicaid. One, so I can get this adoption tax credit, and two, if for some reason that death benefit, survivor's benefit went away, that you could then activate the monthly payment. And I don't know how high. I mean, I think to pay taxes on it, it has to be a pretty high amount, but I'm not a total expert on that. I'm going to go back up since we're on Social Security to Stephanie's earlier question. If a child gets Social Security because a bio parent passed before adoption and it's higher than the adoption subsidy, when the SSI ends, should the adoption subsidy pick back up until graduation? He turned 18 in January. So all income stopped. Should the adoption subsidy have picked up from January till he graduated high school? If he had an agreement, yes, I in a situation like that where you had a $0 agreement, I would, and the Social Security benefits ended, and the child otherwise would have been eligible for continued monthly benefits with the state, I would ask the state to step in until that normally would end. I don't know if we can be successful on that, but Stephanie, I know you, so we can talk about it next week, um, before I do my training for you. Um, I get this credit is not eligible for guardianship. Minnesota does not have an adoption and to my knowledge, guardianship credit. There were attempts back in like '07, '08, or '09 to do an adoption credit, but it didn't happen. Um, um, yeah, Becky's giving me a little more details on that. And if people don't want to wait, last year's adoption tax credit is available on our website now. So sorry to take this 20 minutes over the hour. I can't remember what we put it down as. I usually think I tell Becky to do an hour and a half or an hour and 15 minutes, but you know, I can jabber away like nobody's business. Um, and in our question and answers, someone was asking about California. California is pretty easy. They offer the maximum rate, but I'm happy to talk with you about things further. Arizona, I definitely can talk to people about that. I think right now, what's most important is, I'll go to the slide. I know Becky's been populating this all over the place. But you know, if you've got questions specific to your case, please reach out to me or your state. You know, I did a lot of generic things, but I know a lot about all the states. And so feel free to reach out to me. Email would probably be best since for those of you doing this live, I will be out until next Wednesday, December 11th. Um, so um, there, Becky, it probably take a week, but this will get downloaded and then uploaded to our website. And there will also be an email going out to people who signed up for this. Um, so the slides of the maximum, so that was the federal adoption tax credit. I do think Oklahoma has, I'm not sure if they have an adoption credit. I'd have to, you shoot me an email, I can track that down. They have a really good foster care credit, but I'm not sure if they have an adoption credit in Oklahoma. The federal one is 16,810 federal adoption tax credit. Sorry, I should have been clear that that was federal credit. There are some states that do have state adoption credits. Many of them, um, many of the states that have them are not really useful because they're tied to expenses. Like California has an adoption credit, but they have to be from the foster care system and with expenses. Like, well, how does that happen? So, um, Ohio's in the past, they had this new grant program, and I'd have to do some research on that. Ohio did a really great thing where they said it was up to like 10,000 of expenses or a minimum of 1,500, and that was collecting that was what all the adopting from foster care families were hitting. But you know, that has changed to this grant program, which I think is actually better now. And higher. But you know, it depends on the state. But like you said, I hopefully, you know, it's bored in everybody's head that I'm happy to talk with you after the fact about things. And to some of the questions or some of the things that I brought up, like you know, Brandy in Montana brought up the rates. Like if you're already maxed out, you can't get a higher rate. Well, then the next question is like, I'm going to do a webinar in February about advocating for changes. You know, like how can you talk with your state adoption unit, but more importantly, your state legislature to see, hey, we should get an increase because it hasn't changed in a long time. You know, some states have done that through lawsuits, other states have done it with legislation. So, like, can we do it that way? Or can we get rid of we're going to reduce non-4E subsidy for kids who get, you know, survivors benefits in the state of Maryland. Um, or can we get Maryland and North Carolina and Michigan to allow renegotiation up to their child's current needs? Things like that are things that we'll cover. There's a lot out there. So if you're looking at trying to change the system to make it a little better, I'm happy to talk with you and maybe connect with other folks in your state to see if there's any way we can help you. Because sometimes it's really useful to see what other states are doing. And sometimes that shame is useful. Like I actually spoke in person at our conference in 2019 and said one of the highest rates or eligibility requirements for ages is Kansas, because I knew I had a lot of people from Kansas in the room, is at age 12. Well, guess what? Within a year, or within 2 years, they changed that to age 6. That was just me by saying it in a workshop that changed. It's not always that easy, but sometimes states respond to shame of, oh, we're out way outside the norm. We could do things a lot better. So I'm happy to talk with anybody who wants to try and make things work better in your state too. But also, if you just need specific help to your family, or your families you're serving, because I know there's some great support people on here too, I'm happy to talk to you.
Thanks so much, Josh. That's a lot of info.
Yeah, I know.
You do well putting it in a compact amount of time. So folks, the Josh will have the slides and we'll have a recording that will go out within a couple days as soon as we get the recording uploaded. So you'll have access to information and Josh's contact info.
Thank you, Becky, for all your
Yeah.
help.
Thanks everybody. Have a great rest of your day.
Yes.